Hi there. This is a criminal procedure adjudication topic. It's linked to Chapter 9, Part B2 of the Miller and Wright text. We're talking now about the law of sentencing, and particularly about the way that the rules of sentencing give different actors in the system the ability to look over their shoulder and to think about what has happened before. In particular, what do we think now that we've got a conviction, what do we think now of the charges that the prosecutor filed and that the state proved at either at the guilty plea hearing or at the trial? Are we willing to ameliorate that or enhance that in some way? Do we reconsider the charges? Away we go. In the federal system, we talk about this second look process as relevant conduct. That's the buzzword in the federal system. In the state systems, we talk sometimes about real offense sentencing versus charge offense sentencing. So those are concepts that we'll be dealing with. Let's start with discretionary sentencing systems. Remember, these are systems where the statutory range for the crime is pretty broad. So you might say 0 to 20 years or 0 to 5 years, depending on what the crime is. At any rate, the judge can choose within a wide range, and typically the judge is setting both the minimum and the maximum sentence. And then a parole board comes along later and chooses something more specific within that minimum and maximum that the judge sets. So in this kind of discretionary system where the judge is choosing from a wide range and imposing a somewhat wide range of a sentence, how does the judge think about the charges? In these discretionary sentences, the judge is probably going to want to think about what really happened. Not just what's on the face of the documents, but what really happened here. And if something pretty worrisome happened, there were guns, there was violence involved, something like that, then whatever the underlying charge is, as a judge, I'm going to sentence this person up toward the top of the range that is available to me. On the other hand, if I think what really went on here wasn't as serious, technically, yes, it was a crime of the sort that the statute describes, but one of the less serious examples of this crime, then in that setting, I'm going to impose a range that's more, down on the lower end of the available range. I'm also, as a judge, thinking about equalizing charges. I feel some responsibility as the judge to make sure that if the prosecutor's inconsistent, at least in my view, high sometimes, low sometimes, that I'm one force for equalizing things in the system, at least in a discretionary sentencing system. Now remember that in these discretionary sentences, parole boards also are participating in setting the sentence for particular cases. So we have here one of my favorite scenes in all of American cinema, the parole board hearing from Raising Arizona. Parole boards are also thinking about what, in their view, really happened. So even if the person's charged with ordinary robbery, not armed robbery, they're still going to care, was there a gun? And they're going to be looking through the file for some indication that a gun was involved in the case, or some other markers of violence. But they're going to be asking not just what were the elements of the offense, but what does the file tell me happened here? That will be relevant to the parole board in deciding when actually to release someone within the range of minimum and maximum that the judge helps to establish. Now, what happens when we move to a world of more highly structured sentencing laws, maybe in a state with sentencing guidelines or other statutory structures that take some choices away from the sentencing judge and from the other case level actors? Well, in this world, we talk about real offense sentencing and charge offense sentencing. And for charge offense sentencing, this makes a lot of sense to lawyers. It's just, whatever the sentence is, it's going to be based on the conduct that, the prosecution proved as you go through and get proof beyond a reasonable doubt for each element of the offense that you charged. And yet, as we just saw with discretionary sentencing, The reality is that other things matter to sentencing actors. And so what really happened, what was the real offense, not just what was in the indictment, matters traditionally to parole boards and to judges in a discretionary system. And some structured sentencing laws or guideline systems also allow different sentencing actors to account for the real offense sentencing. Now, there really aren't pure real offense systems or pure charge offense systems. There's some mix of both of those involved in every sentencing system. But you could think of them as running along a spectrum. And so the federal system is closer to the real offense sentencing end of the scale. And then most state guideline systems are closer to the charge offense end of the scale. But you can find elements of both in every system. Let's think about what the different system actors, how they react to these different kinds of systems. First of all, think of the sentencing judge. Does the sentencing judge tend to like real offense sentencing or charge offense sentencing? Well, on the one hand, you might say real offense sentencing probably tracks more what judges do in discretionary sentencing systems, and it gives them a little bit more flexibility to consider a wider range of things that they may believe to be relevant. On the other hand, there is something unsettling for lawyers, for law-trained people, particularly for judges, about having big consequences turn on things that may not have been proven beyond a reasonable doubt at trial. So there may be some concern about relying on it too heavily, and in particular relying on the submissions of the parties, especially say in a guilty plea case, to tell the judge exactly what really happened behind the charge. So at any rate, judges are probably going to see some traditional benefits in real offense sentencing, but there will be some concerns to the extent that drives a larger and larger component of the sentence. And what about the prosecutor? What does the prosecutor think about real offense sentencing versus charge offense sentencing? Well, if you're way over on the real offense end of the scale, as in the federal system, on the one hand, as a prosecutor, you might think, this system is designed to ignore my charging decisions earlier on. It says to the judge, you're not bound by the facts proven at trial. You can get beyond that. And that, as a prosecutor, might leave me less influence over the final sentence. On the other hand, I might think as a prosecutor, well, real offense sentencing, it's based on the judge's view about what really happened, but where will the judge get that view? Very likely from me, and maybe from the probation officer, and perhaps to a lesser extent from defense counsel. And so it may be that this works out pretty well for me because the parties have such control over the facts, particularly those facts that don't come out at trial or during the quick factual basis during a guilty plea hearing. So in that kind of world, maybe it's a good thing that the defendant gets punished for certain things that weren't a formal part of me as a prosecutor, proving each element of the offense beyond a reasonable doubt. So again, as a prosecutor, I'm probably torn, but I could see some advantages in real offense sentencing, even though it's designed to second guess my choices. Now you have before you the language from the relevant guideline provision from the federal sentencing guidelines, FSG 1B 1.3, kind of a cheer or a rap, I don't know what it is. Anyway, it's memorable. I want you to stop now and take a close look at the language. So when the judge is trying to decide which guideline range is going to apply to this case, the judge has to think not only about the prior criminal record of the offender, but for our purposes here, the important thing is how serious was this offense? And so the charge of conviction is the starting point, but then under the federal sentencing guidelines, if you think that the charge didn't really capture everything that was going on, then you might bump it up to a higher level. Or if the charge leaves a false impression that it was too high, then you might bump it down a little bit. As you're going through that process, as you're bumping the charge up or down, changing the offense level to be higher or lower, in that setting, the guidelines say that all acts and omissions of the defendant are going to count. And then if you're acting in concert with others, then all the foreseeable acts and omissions of others are going to count against you as part of the seriousness of what you've done. And then you're thinking not only about what the people did, but the results of what they did, all the harm that resulted from their acts. At least anything that was the object, any harm that was the object of such acts, that can be included along with the harm that actually happened. So those are the categories for under the federal guidelines, 1B1.3. Let me give you 3 quick examples so you can think about how this might work in this real offense, or what is sometimes called a modified real offense system. In this system, suppose somebody is convicted of robbery, not armed robbery, but just robbery. But the judge says, you know, from the testimony I heard, I think a gun was involved. So the judge has in front of her a case that was charged with robbery, conviction of robbery. She thinks a gun was involved. In this setting, could the judge move up the sentence based on the presence of this gun that was not an element of the offense as charged? All right, now our second example, this time relating to the acts of others. Imagine a drug conspiracy. You've got somebody charged with taking part in the drug distribution, and it was part of a larger group with large amounts of drugs being involved, at least with somebody in the group. If the sentence is to some extent based on the amount of drugs involved, if my current defendant only directly helped to distribute the first 2 kilos of cocaine, but there were another 6 kilos that came in the same night through the same organization, and this defendant, you know, it was reasonably foreseeable to this defendant that those other 6 kilos were going to come in, then the judge can consider the whole lot, the whole 8 kilos, when setting the seriousness of the offense for this defendant. Third and final example, this one relates to the harm caused or anticipated by the defendant. In this case, I remember the illustration from the federal sentencing guidelines themselves. If you've got defendants Frank and Gina together, they design a scheme to sell fraudulent stocks by telephone. Frank pockets $20,000. Gina obtains $35,000 when they're working separately on their jointly conceived plan. Both of them, if they're tried and convicted or just convicted of mail fraud, each of them is going to have an offense level that will be set in part based on the amount of harm that they cause, the amount of loss to the victims, and you will count the whole business for both of them. So you'll count the $35,000 for Gina and the $20,000 for Frank. For both defendants, you'll add it up to $55,000. Now we switch to a charge offense rule. One example here is Florida's Rule of Criminal Procedure 3.701D11. In this world, notice again that we're talking about what reasons can support the judge deviating from the sentencing guidelines. Now, this does not tell us what the judge can consider when setting a sentence within the guideline range. When it comes to that, the judge can still consider anything that the judge thinks really happened, any aspect of the crime. But in terms of switching from one guideline range to some other guideline range, up or down, the judge is told under this rule, here's the key phrase, that you can't switch if it's based on something for which convictions have not been obtained. So under this Florida rule, if you had a defendant who was charged and convicted of simple robbery, no armed robbery, just simple robbery, but the judge believed that there was adequate testimony to prove that there was some kind of use of the gun in the robbery. Could the judge consider that in Florida as a basis for increasing the relevant guideline range? And I think under Rule 3.701 D11, the answer would be no. The prosecution could have charged armed robbery. Instead, they charged simple robbery. So even if the judge believes that a gun was present, if the prosecution did not obtain a conviction relevant for that fact, then you can't consider it in moving to some different guideline range. The same would be true for obstruction of justice. If you believe that the person was lying to the police or maybe lying to the probation officer or something like that, could you increase the sentencing guideline range there? And again, I think the answer is no, because the prosecution could charge obstruction of justice, but convictions have not been obtained. Now, I mentioned before that there are no pure charge offense systems or pure real offense systems. And so in this setting, you'd have to acknowledge that the Florida judge, even with this fairly tight rule under Rule 3.701, would still be able to consider certain facts that go beyond what was necessary to prove each element of the offense beyond a reasonable doubt. One example would be the defendant's refusal to accept responsibility for the crime. If the defendant is still saying, I didn't do it or I didn't do anything wrong, there shouldn't be such a law. Traditionally, judges have thought about that in setting sentence and have said, if you're not really accepting responsibility, then you're not amenable to probate or not amenable to rehabilitation, and that's going to affect what sentence I'm going to propose for you or I'm going to impose on you. So that's not a chargeable offense. That's not a setting where you say the prosecutor had a choice, they chose not to charge it, and therefore we'll have to ignore it at sentencing. So even under the tightly controlled, or at least relatively tightly controlled Florida system, there are certain parts of the defendant's conduct, some of them that may relate to the crime itself, that are just not going to be a problem for the judge to consider because the prosecution was not foregoing charges based on that unproven fact. Our illustrative case for this relevant conduct, real offense, charge offense, sentencing doctrine comes from the state of Washington, State versus McAlpin. So we've got a robbery conviction here. Prosecution comes in and says, all right, we've proven a certain level of robbery. So in our world of sentencing guidelines, you have grids with horizontal and vertical movement. So we can move it up to a more serious sentencing level because of this level of robbery. And the prosecution says we can prove some prior criminal activity by this defendant, so we can move it over, moving to my right, I guess your left. We can move it over into the more serious area of the grid, over to the right of the grid, because we can prove some prior convictions. We've got some recent convictions for burglary and conspiracy, and we've also got 2 prior juvenile convictions for second-degree theft. And prosecution says, we got a lot of information about this kid. Here is the juvenile file, boom, on the desk. It's hundreds of pages long. And it turns out that it's got these 2 prior second-degree theft crimes that count under the rules. But then there are a lot of other juvenile offenses, that are documented in this file. 5 different felonies before the age of 15 when they don't count under these rules, and 2 misdemeanors between the ages of 15 and 18. Again, misdemeanors as a juvenile don't count for purposes of adult sentencing. So the prosecution says this big juvenile file ought to convince you, judge, to go up to the top of the designated range that we're aiming for, which is 46 to 61 months. The judge listens to all this and says, okay, prosecutor, I will see your bid and I'll raise you one. The judge ends up not only going to the top of the range, but actually shifting the range into a more serious one and saying, I need to put this guy into a different range because I'm going to need to depart from the guidelines, in essence, because the stuff that isn't counted yet under our rules for finding the right box on the grid really are important here. So I'm going to think about those juvenile convictions that don't count under our rules, and I'm going to think about some of the other unsavory things that I'm learning about this defendant in the file, and therefore, says the judge, I'm going to impose a sentence of 90 months on this defendant. Defendant appeals and says, hey, wait a minute, you can't use this unproven material to bump me up from 61 months to 90 months. On appeal, the Washington Supreme Court affirms this sentence and says you had two different reasons, trial judge, to depart up, to go outside the guidelines range. And one of those two reasons was good enough. In particular, the juvenile convictions that weren't counted under our accounting rules for finding the right location in the box, nevertheless could be a basis for going above that. That was what the statute would call a substantially compelling reason for a departure, and therefore the court affirms. Notice that the justices end up saying here that if there is a juvenile conviction for somebody based on conduct before they're 15, even though the statute is silent as to those, the judge can consider it, but doesn't have to. The statute just tells the judge you have to consider it once the person has turned 15, and it's something between ages 15 and 18. So discretionary before 15. After that, statute says you've got to count it in your location of the box. The Washington statute, like the Florida rule that we saw earlier, tells a sentencing judge that if you've got some kind of facts about this defendant's conduct, either in this case or in related cases, if those facts establish some elements of a higher crime, a more serious crime, additional crimes, they cannot be used to go outside the presumptive sentence unless those crimes are actually charged and proven. And so that's the distinction the court is getting at here. They say those juvenile crimes, they were charged and proven. But these crimes that the defendant admitted when talking to the probation office, or the juvenile offenses that were handled informally in the system over the years as reflected in the file, you know, there's something in the file indicating that it happened. There's some proof here, but for Washington law, the key fact is, was there some conviction involved? If so, it can count. If not, for these purposes, not a substantially compelling reason that can justify a departure. So this is the wrap-up question for this unit. What difference does a conviction make? Well, for those of us with lawyerly instincts, a conviction should mean something. And the fact that a prosecution team has put together proof beyond a reasonable doubt for all the elements of the offense, that in our world means a more reliable factual basis for a sentence. If the fact, the behavior of the defendant that is at issue was not proven, was not the basis for a conviction, but proven through some other method, we may start thinking of that as less reliable. And so we start making these trade-offs, deciding to what extent do we want the judge thinking about something that may very well have happened, some serious proof involved that it happened. To what extent do we want the judge to think about that, given that it wasn't proven using the highest quality proof machinery that we have, which is proof beyond a reasonable doubt at trial after, you know, witness examination and cross-examination and so forth. Every system gives a mixed answer to this question, but whenever you're moving toward a real offense system, You're saying we're willing to trust the relevance and the accuracy of facts that maybe they could have been proven at trial, but they weren't proven at trial. To the extent that the prosecutor is talking about something that is not really a part of the criminal code and just is something that judges traditionally consider at discretionary sentences, at discretionary sentencing, we're more comfortable with that. But we're moving away from proof at trial to proof through some other method. All right, that's it for this topic. On we go.